Are you being sued by a debt collector? Are you being sued by a debt collector? There's a tendency within the legal space, the credit space, where we fear a creditor more than we fear a junk debt buyer. And there is good reasons for that. Very good reasons for that. But I want to tell you that both the junk debt buyer and the creditor in most cases have the same problem. What is this problem? Welcome back to Credit Nerdery. Welcome back to Credit Nerd, brought to you by Kyrene Financial, Kyrene Credit Products. There is a problem that exists within the legal space of where debt is concerned. The court systems are being used as a means to ambush consumers that doesn't know their rights and doesn't have enough information to defend themselves. But there's always a lot of time and emphasis on defense against a junk debt buyer, because that is a bit more tedious and a bit more easier to get over. Tedious from the perspective of the junk debt buyer has more to do on their part in order to prove their case than sometimes an original creditor. Also, there's a presumption within the context of the court where once a creditor comes to the fore that is an original creditor, especially the big banks, the court tend to view them differently than it views a junk debt buyer. But do not be afraid of the creditor. Do not be afraid of the junk debt buyer. Both the creditor and the junk debt buyer have a problem. And the problem that both of them have is a documentation problem. It would be shocking to tell you that sometimes in certain jurisdictions, more original creditor cases get thrown out than there is junk debt cases in certain jurisdictions, not everywhere. Because both of them have the same problem. In order for them to prove their case, and what they tend to do, and I would admonish consumers not to give in to this, they file their case as a means to intimidate the consumer in settling so that they can get payment. And another reason is to get a default judgment so they can go and enforce the collection of the debt. But as a consumer, answer your case. Answer the case. Answer the case. If they get a default judgment and you didn't know about the case, then there's a way that you can battle and try and get the default overturned, but it's not easily done. But answer the case. Once you answer the case, a lot of time, the junk debt buyer and even the original creditor, knowing that their documentation is sparse, they will go ahead and dismiss the case. Sometimes they will fight on, and what they will do to you is try and get you to settle that case before it goes to trial. But if it is the case that you give a good answer, what you need to do in the answer, deny everything except if, as long as your name and your address is correct, then you can always affirm that. But deny everything else, but you have to know how to deny it where it doesn't become a problem where the court see you as lying to them. You have to word it in such a way where you keep yourself neutral, where it is not seen that you are blatantly lying. Let them come to court and prove their case. Let them prove their case. And a lot of times they are not going to. Because they can't. They can't. One of the things that they do, one of the tactics that they do, and this is not the requirement for every jurisdiction, but I'm going to give you this. And in your jurisdiction, if you are sued or your client is sued, you need to pay attention and search for this. In some jurisdictions, the case cannot be filed under the civil rules of procedure in an appropriate way unless the account agreement is attached to it. Not every jurisdiction mandates that, but some does. Some do, I should say. As a result, check your jurisdiction. And if it is the case that that is a requirement, you strike the claim so that they have to amend the claim and do it over. And a lot of time they are not going to do it because they don't have the documentation to do it. They don't have the documentation to do it. When you answer the claim, make sure you check if that is the case. In my next video, I'm going to give you 2 ways that you can defend yourself against the lawsuit, with whether it be original creditor or junk debt buyer. 2 ways you can defend yourself, but most of the time, one of them is junk debt buyers will fall onto that. I use that mechanism to get you up. So once you go, don't just give in, don't settle off the top. I'm gonna tell you why you must not get afraid and settle off the top. A lot of times when you go in with case like this, and remember, I am not a lawyer, so let me give the disclaimer. I am not a lawyer. I'm not pretending to be one. I am just telling you from experience and from our continuous educating ourselves. What they will do to you is this. Prior to the trial, they will call you and try to settle. Don't settle right away. Don't settle. Once you file your answer, I'm gonna give you ways to defend yourself in the next video, as I said. Once you file the answer, there are several things that you have to do. You can you after your answer, depending on what you do, depending on the case, which in the next video I will tell you what you need to file after your answer. But why I tell you don't settle off the top? On the day of trial, for the most part, the judge is gonna give you an option to settle. Sometimes it's not gonna get to trial because the junk debt buyer and the original creditor know that they don't have the documentation to prove the case, but they are banking on people's fear of going into court to defend themselves, and they are banking on ignorance where procedural maneuvers are concerned. But remember, I tell you, make sure you check your jurisdiction and see, because you can strike the case before you even give an answer. You can strike it if there are certain documentation that must be filed, and a lot of time both original creditors and junk debt that are just file a bare bones case of state, they usually state something like this: X, Y, and Z or Jane Doe or John Doe owes X amount of dollars. Here's an agreement that they entered into, and they violated that agreement, breach of contract, and they never disputed the charges, and they were given statements on a monthly basis, and they never disputed any charges on this. As a result, blah blah blah. That's what you're gonna see a lot of times in the most preliminary filing. But as I said, you might be able, depending on your jurisdiction and the rules of procedure, they might have to attach the truth and lending disclosures and the original credit to justify the charges. Check your jurisdiction. If that is supposed to be also the service, you can get it strike on the basis of service, because sometimes your jurisdiction, and in most cases you have to be served a certain way by a certain time before they can mail you anything, and sometimes they don't even mail you, and sometimes the servers are doing what is called in the legal world sewer service. They're acting like they serve you when they didn't. A lot of different cases have this kind of issue. All of these things you can use to defend yourself in the beginning. Now, back to the problem that both of them have. Both of them have a problem with documentation for the most part. Most time when the original creditor open the account, shortly after that account is open, they don't have any of the account documentation. They don't have the original contract. They don't have certain things. they will use the statement as a means to get at you. But a statement just states transactions that were made and when they were made. They must prove that you are the one that made those transactions. They have to prove that, and you have to hold them to prove that. So what you do, don't settle. Let me wrap up. Don't settle until you do one of the things you can do while you are waiting to go is to do discovery. Request documents from them. Make certain interrogatives, admissions, send it over to them. Sometimes they will try and ignore you, but send it with enough time. And some jurisdictions give you 30 days where they have to answer your request for documents and stuff. Some do 35. You'd have to check your jurisdiction. Some do more. But do this as early as you can. You have to check your civil procedure and see how soon you can do this. Do this as soon as you can so that the trial date is not set. Because sometimes what the attorneys will do, if you do it with a few days left before the trial, they will fall within the time frame and they can use that and not supply to you and turn up a trial without giving you any of those things. Even though you can go there and tell the judge that, Judge, I am not prepared because I made requests and I didn't get it, and I cannot sufficiently defend myself the best way possible because I didn't get it. But they will do that to you. They will do that to you, not give you the documentation that you need. But if it is a case where you do it and the time that you have before the trial is enough time where they have to give you, and then there will be in violation of the law, then you can go and file a motion to compel them to give it to you, or go and ask the judge to give summary judgment in respect to admissions, count the admissions as valid because they didn't respond, and on that day you get rid of the case again. So these are some of the ways that you can defend yourself. Why you shouldn't jump to settle? If you use this method and they supply you with the document, you can get to see what information they have on you before you give in to anything, even with your account. You can get to see, and you might realize they don't have the necessary documentation to prove their case. And from that, you can go and mount a defense. You can go and mount a defense and defend yourself. But one thing you can't do when you go there, I have never seen any case where the defendant, when they are sued by the original creditor and the junket buyer, when you go there at the trial, if all paperwork is good and everything, and they don't disown the debt and they get away. The judge always use that to say, all right, they didn't disown the debt, so as a result, rule in favor of the plaintiff. So you gotta figure out how you're gonna do that. I can't tell you that you should do that or how to do that. You gotta figure out how to do that. But yes, don't pay the original creditor, nor the junk debt buyer. Don't pay the original creditor. Most people fear original creditors. They have the same problem as junk debt buyers. They don't have documentation. And you can beat them if you apply the rules and understand your rights and understand the rules that govern where you actually are, where you are actually defending yourself. Alright? I don't want to be too long on this. Catch me on the next video for the ways to defend yourself.